Welcome, you guys on Zoom, you guys in person here. We got a class today. 2-hour C credit is awesome, but this topic is even more important because people can screw things up. So I'm excited about this today because I actually had a client, this is years ago, called me to sell her mom's house after she died. Her mom didn't know what she didn't know and put her on as joint tenant before she passed away. So there was like a $27,000 purchase and a $800,000 sale going on that now daughter owed taxes because they did it wrong. So you don't know what you don't know, and that's why these classes are important though. You guys are going to get some talking points today that you should be making a reel or a post or a SOI touch and sharing, hey, did you know X? So take notes on some of those things and inform your clients, your friends, your families that, this is an important topic. And then of course you can send them to Kristi to really talk about how to set things up properly. So anyway, thank you. You're up, Kristi.
Thanks, everybody. Appreciate your patience today. Just so you know, I am a licensed title officer, escrow officer. I've been in the title and escrow world for over 25 years and served as a manager of an escrow office for many years, about 21, and been our compliance director for U.S. Title for about 4.5 years. And now am the director of compliance for U.S. Title and the regional manager for First National Title as an underwriter in the States, in the Western United States. So anyway, so yeah.
Oh, sorry, I was even trying to make that go away.
Yeah. Anyway, so I have so I've seen a lot of things as time has gone on, and I always joke that I can't do your job. I've thought about it over the years and thought maybe I should give it a try, and every single time I think, nope, I'm not going to do that because I don't have any tact. You guys are awesome. That's just basically it. I would go to, I couldn't handle it. I would go to funerals and other events and divorces and things like that equal business for you guys, right? They do. I mean, it just kind of happens. And I'd be like, yeah, there's a dead guy over there, but let's talk about the house. The house is gonna go for sale, right? So it's kind of terrible, but unfortunately, things like death and divorce and things like that often equal business opportunities for you guys. They just do. So you guys are a lot better at navigating that delicate world of when people pass away in title. We have a really experienced escrow officer in the back, also named Kristi, spelled differently, but and she's way cooler than I am. But there's Kristi right back there. She works out of our Union Park office, and then of course Jen is our salesperson, so she handles basically the Wasatch Front. I heaven's sake, she keeps expanding her her area, but she's all over the place. So anyway, lots of experienced people to help you as different transactions come up. And I laugh because a lot of people get sort of bored at their jobs and they look at the clock and they watch time go by. I've never done that. In 25 years, I watch the clock, but I mostly go, oh crap, I need more time. Oh crap, I need more done in a day, that type of thing. Because we always see new situations show up. At the end, I'll give you my contact information. You can always call me and say, okay, I have a new situation, haven't seen this before, this one's a wacky one. And sure enough, either I've dealt with it before or we want to figure it out and find a solution, because there always is a solution. It just sometimes isn't super fun. Anyway, but all of these things and what people do while they're alive affect what happens after they pass. Sometimes they know what's going to happen after they pass. Sometimes they have no idea. Sometimes they don't care, right? You ever have those family members? They're like, it's not my problem. You guys get to deal with it after I'm dead. Like, thank you very much. Yeah, I'm related to a bunch of those people. Anyway, so I'm just going to drag them in and force them to do it. So I'm just like, yeah, exactly. Thank you for being all my bad examples, people. I know these are the people that also say, if I bring my car title, can I get a loan? Like 25 years, you still don't know what I do. But anyway, it's fine. It's okay. I just stopped talking to them. I'm like, oh, family reunion, I'm going to go over here. Anyway. So, but a legally authorized person has to convey title on behalf of a deceased person. We can have all the seances in the world, and we still need live people to sign on behalf of deceased people. It's got to happen. Any type of estate planning that the people did before they passed will affect how it needs to be transferred after they pass. So, unfortunately, what they do or don't do before they die greatly affects the people that are left afterwards. So we need to deal with this. Feel free to laugh at my photos because I think they're super funny. At 3 o'clock in the morning, I usually do these like very late at night, and I crack up all by myself in my home office. And then I come and teach the class, and I'm like, so anyway, so it's kind of funny. Anyway, I find super funny things, and then later on go, maybe that wasn't as great as I thought. But how many times do you go through a listing appointment? You've looked at it, someone's told you, well, mom and dad have passed away, or somebody's passed away, and you show up and there's someone who thinks they're in charge, right? There's someone who is acting in charge, right? Is that person always in charge? Sometimes, right? Sometimes, not always. My favorite is when the person who's actually in charge, but their spouse is acting in charge. It's the child who has been given legal authority due to whatever estate documents have to be in place, but sometimes the spouse of that child is sort of acting as if they're in charge, that type of a thing. That seems to happen a whole bunch in my family. Always like, but you have nothing to say about it, literally nothing. But thanks for your opinion. So be wary when you go on those listing appointments. Sometimes the person who's acting in charge may not necessarily be in charge. They may think they're in charge, or they may have meant to have been put in charge, and that happens a lot too. Just because people just don't get around to it. But we're going to go over 3 different types of estate planning options and the way that property can be vested after people pass away. We'll deal with trusts, both revocable and irrevocable, tenancy, joint tenancy, I'm sure you've heard of, and then tenancy in common or sole ownership, and then probate, dealing with testate and intestate, dying with a will or without a will. So we'll deal with all of those. First, let's talk about trust. I teach an entire 2-hour trust class, and it is still the one that gets the most questions. It used to be when I was a kid that the only properties that were held in trust were people that didn't invite me to their parties. It was like, like rich friends and people that had horses and stuff like that. So now you can have a regular house and a regular subdivision in a trust. You don't need like trust income or a trust fund kid or anything like that to have your house in a trust. It can be a property in a subdivision. It can be a little tiny property on, Blair Street downtown to be in a trust. It's just an estate planning tool. They are used for income distribution and things like that for handling large incomes and distribution of that income, but they also are used for purely estate planning purposes. How many people in this room have a trust? Does anybody have one? Yeah. Good idea just to have one, just for your wishes to be known and to avoid. Thank you. Thank you. Yeah, it avoids probate. Trust can eliminate the need for probate and basically make your wishes known. There are several reasons that someone may want to avoid probate. It's not necessarily the worst thing in the world, and we'll talk about that at great lengths. But it can eliminate the need for probate, and they can be, Kristi can attest to this, trusts can be long or short. I've seen trusts that are over 300 pages long, and we've seen trusts that are like 6 pages long. It just depends on the need of the trust and how complicated they want them to be. Sometimes people in Utah tend to make all of their children their successor trustees. They love to. We don't want to leave anybody out, and they have a lot of kids. So sometimes that makes their trust quite lengthy. Anyway, and then their kids groan as soon as they read the trust after mom and dad pass away. And they go, oh, seriously? Anyway, so it kind of presents some problems sometimes. But in order for a property to be conveyed, and we're talking about real property here, not personal property, of course. But in order for a property to be conveyed out of the trust, they must deed the property into the trust at the county recorder's office. This used to happen a lot when I was working in an escrow office, is that people would pass away. Mom and dad's house is in a trust, don't you worry. We'll pull up the title report, we'll say, I see mom and dad's name on here. Oh, well, I have their trust. It's in a 3-ring leather-bound binder. They paid $3,000, $4,000 for that trust. The attorney prepared a document from their names as individuals into the name of them as trustees of their trust and put it in the front sleeve of that 3-ring binder and gave it to mom and dad and said, go to the county recorder's office and record this. And mom and dad said, you betcha, sounds good. They put it in their filing cabinet, put it away, and then they died. So is that property in the trust? No. Is it able to be used to transfer the title of that property out of the trust? Did they waste their money on the trust? So that used to happen a shameful amount of times when I was working in the escrow world. Now, I just recently, 6 months ago, referred a family member of mine to my favorite trust attorney, or one of them. And I kind of waited to see what happened in regards to this. I was not going to let them, of course, not get the property recorded into the name of the trust. I was going to follow up later on, but because I don't work in an escrow office, I decided to see what the attorney that I refer people to did with this. If he dealt with it, if he gave them a deed, put it in front of the thing and sent them on their way. He did give them a deed, told them to record it, sent them on their way, and then he called them a couple days, about a week later, and said, did you get that recorded at the county recorder's office? I bet you Kristi could help you with that if you need help with it. And they said, oh, we need to do that. Then he sent them a letter in the mail saying, hey, reminder, you need to record that at the county recorder's office. Your trust is not going to be valid for your real property unless you record the deed that I prepared for you at the recorder's office. And they said, oh, cool, okay. And they brought me the letter and they brought me the deed. And I was like, that's cool, that's neat. Then he called again about a week later, or his paralegal did, and said, hey, did you get that deed recorded at the county recorder's office? And they said, as a matter of fact, we took it to Krisi, took her the letter, everything's all recorded. And they said, okay, good, sounds good. So I don't know if it would have called again, I don't know, but I thought that was very cool. So hopefully I have hope that that attorneys are coming around and understanding that that's a very important part of transferring the real property, which is typically people's biggest asset when they get a trust done. And hopefully they're helping people. But I taught this class yesterday, and there's 3 agents who said, nope, it's not happening still. So people are dying, and then they're finding their family trust, discovering that there is a deed in the front of it that was never recorded at the county recorder's office. So if you have clients that are getting trusts done and asking you for referrals of attorneys, stuff like that, give them a referral of a good attorney, and then tell them, you will, chances are you will be given a deed at the end of this that must be recorded at the county recorder's office. All of this is for naught unless you record it at the county recorder's office. Don't let that not happen. Okay? The law of the trust. This is my favorite joke, but this is the Utah laws in regards to trusts are very liberal. It's the only it's my political joke. I'm off myself. Okay. Anyway, the only thing that Utah's liberal on. Anyway, but okay, I'm all done. Anyway, look, I worked in Sugar House for 21 years. Okay. Anyway, so meaning that the laws in Utah in regards to trusts are very much refer back to the trust agreement. There's practically no provisions in Utah state law that guide us in reference to trust. They all say, refer back to the trust agreement, refer back to the trust agreement, refer back to the trust agreement. So what does that tell you and I? That tells us that we better have a darn good trust agreement, right? If the trust agreement is crummy and crappy, it's not going to help us. Utah law is not going to step in and say, well, in case the trust agreement is ambiguous and doesn't make any sense and doesn't help, then this law takes precedence, or this law helps out. There's only one area in that it helps out in. Every other area, it says go through and do a court proceeding, which is essentially probate. So you're basically stuck doing essentially a probate proceeding if your trust agreement isn't very clear and very well done. So that's why I always tell people you get what you pay for. You can get a lot of trust agreements done by attorneys that don't do them full time. You can get them done by attorneys are like doctors. You wouldn't necessarily go to your podiatrist and ask about your headaches. It's probably a bad idea. Stuff like that. Same thing with attorneys. If you want a trust done and you want it done well, go to an estate planning attorney. Most attorneys will have sort of an estate planning package wherein they do a family trust for you, they'll do a health directive, a living will, durable power of attorney, those sort of things, and they'll do like a package type thing. That's pretty common for most estate planning attorneys. If you go to a divorce attorney and ask them to do your family trust for you, it might not go so well. Just because that's not something they're they're practiced in doing. So just want to make sure you sort of get what you pay for and are cautious when you refer out people to do trust for your clients, because then you may have to deal with the backlash of that after someone dies and then you want to sell. Typically when a trust is set up, that was weird. Whoa, I moved here but not here. Go. Me. That's weird. Oh yeah. Where did my Zoom thing go?
That's on that screen.
Sorry guys, hold on. Okay.
Thank you, government.
That's what I was trying to do. Jen, there's a chat question in there. Can you see what that is? Okay. Actually, can you see your email? Let me try and email this program to you, because I tried once before and didn't work, and I'll try again. Because my IT guy that I called, he said, this is probably the only one that might work if you try and send it. He said, we've tried to send all of them before, but this one might actually work. I'm like, really? Now you tell me?
Maybe we could get this all set up for you.
That's like,
So I was just saying that she needs that done, probably referring to the deed transfer.
okay. That, yeah,
So do you guys have a lot of people in the office?
do you guys have a list of attorneys that you send people to regularly? Do you just sort of, does everybody have their own?
Personal attorneys that I refer. I don't
like
have
to
to
send people to. I kind of have, I have a list of my favorites. I sort of have the you know, most cost effective. And then I have the one that I consider the most value. You know, he doesn't sign people up for things that they don't need, but he will give them the most bang for their buck, if you will. So that's sort of what I like the most.
And that's a list these agents could reach out to you and get.
For sure. Yeah, absolutely. Oh yeah, he'd love the business. That's true. Yeah, you're absolutely right. Okay, fine. Moving over to, he has his own practice. The one that I referred to as the most cost effective. His name is Jeff Scobie. He runs his own practice. He's been part of another law firm for years, but he just decided to do his own. His last name is the worst ever. It's FKOUBYE. Isn't that terrible? I was like, yeah, but it's Scobie. His email address is Jeff at S as in Sam, N as in Nancy, J legal.com. Actually, can you see that? Never ever had this. Sorry, guys. The other one that I sent out that is a little more cost effective. She's great. She just I just think she's really cheap. I'm always like, is that it? That's all you're gonna charge us? Is Billy Crocker. Billy, like Billie Eilish. Billie. Last name Crocker. Crocker. And her email is bc@crockerlaw.net.
Disconnect from that
Yeah.
screen and I'll steal it.
And even get the Zoom link to pull up now.
Well, you all muted all the.
Yeah, I'm just going to quit Zoom. There we go. Now it should. It's Ryan. Nothing.
Keyword is tech.
Yeah, thank you.
We're going with that.
Come on, disconnect. It's not the deal.
Okay, we're turning around. We're
I'm
good.
so sorry. I've never had this happen. It's I could talk super fast. You've seen auctioneers.
Give us the
Kidding.
2.0 speed version.
It won't even let me quit. Can you stop and look right here? Quit Zoom. No.
I'm just shutting down the computer. My right, the lights.
Did you?
They just won't do it connected. You're connected to that. So it's not shut down. That's weird. You're like locked in. It's all those damn passwords you have.
I think so. It's like you
Or
done.
everything. You must have missed one.
Mr. IT and I are going to. Okay, if you guys can hear me, just hang with me for a second. We're working on PowerPoint. But usually when you set up a trust, you can it's established with a the original trustee, trustees, and the beneficiaries. And typically when it's set up, if it's being set up by people that are still alive and they would like to handle their own home and handle everything, their own business and affairs, they'll be all the same thing. Oh. I should never believe that.
Where were we?
What was the last time I ever did that? Okay. Oh my gosh, bless you. Okay, thanks for the. I don't really need that part on this. Okay, so usually the trustors, trustees, and beneficiaries are all the same while the trustees are alive. So you'll have mom and dad that create a trust, and they'll make themselves, the trustors are the creators of the trust. The trustees are the people that control the trust, and the beneficiaries are the ones who benefit financially from the trust. So those can be 3 different people, they can be several people, they can be all the same. So if you have mom and dad that are setting up a trust, when they begin that trust, chances are they will be the trustors, they will be the trustees, so they're in control of the trust. And then the beneficiaries of the trust also, meaning that it's their money, they can do with it as they please. Then once they pass away,
It's when I click on something, it freezes it. So.
then when they pass away, then they will have designed, or designated a successor trustee to take over. So that can be a see, it's changing here, but not changing here. That can be,
I'm convinced it's you at this point.
oh my gosh, that could be like a kid or anybody they choose, and it can be as many people as they want to. Like it can, that's what I was talking about with Utahns. They like to appoint all of their kids as their successor trustees. So they it's sort of funny.
I'm just sharing this one right now.
That's really fun.
Is there any benefit of why you would do that?
They kind of do it because they don't want to hurt anybody's feelings. That's sort
Because
of
they don't want to have like this one kid in charge.
right.
They
Because
don't want to let them know who their favorite is.
pretty much,
Yes.
And now hopefully if they have a good attorney, Jeff or Billy, will tell them, please don't, because literally the trustee is the person who signs on their
Yeah.
behalf, like that's it. So you can have one person sign, you can have two people sign, whatever, but it doesn't matter because the beneficiaries will still be all 7 of them. That's what matters, is the money will still go to all 7 of them. And if you have 7 children and they all live in different parts of the nation, boy, that's a pain to have all 7 of them sign every listing contract, every amendment, every contract that comes down the line, like that type of a thing. That's just annoying and it's kind of a pain for your kids. So that's the biggest problem, is that it creates trouble for them having to sign.
So potentially though, the successor trustee could be like the decision maker though, right?
Yes, that's true. They are the decision makers,
'Cause
yes.
they really don't need authorization or agreement from the other people. to-
Unless you put that into the trust.
Mhm.
You can put it into the trust that the successor trustee may act on behalf of the trust, but they must receive a majority vote from the beneficiaries. You can absolutely put those type of terms in there. Usually what happens is they'll put in a clause that says something to the effect of these 2 successor trustees must act together and they must receive a majority vote from all beneficiaries or something of that nature, something like that. That's pretty common, or usually the parents know the kids well enough to know this kid will represent these 3 and this kid will represent these 4, like that type of thing. So that's typically what happens.
I can't even disconnect from it right now either. I'm trying to duplicate it. So it shows this one and it's not.
It's like it's holding on and then not letting go. It's the Bluetooth connection.
Well, it was doing it on both of our computers.
So when you guys go on a listing appointment, how do you know, and you've looked it up and you see that the property is vested under a trust? How do you know who signs on behalf of it? Who should sign your listing agreement?
I asked my escrow officer.
There you go, that's right, good.
Say the question again.
So if you've looked it up at the county and you see the properties in a trust, you go out on your listing appointment, who signs your contract?
The trustee.
Very good, that's good. How do you know who that is?
Get a copy of the trust.
Yeah.
You get a copy of the trust. You're
I
like,
was gonna say, well, you look at it, right?
There, yesterday I ran across an agent, he's like, okay, I've been doing this for 36 years, I've never asked my clients for a copy of the trust. I'm like, that's because we do it for you. We have a whole bunch, you never have, we know. But it never hurts, and we don't mind if you blame us, you know what I mean, like, it's a good way to do it. Because a lot of times people are hesitant to give that up, it's their personal information, it's just why they don't get recorded. Some people also think that they're recorded at the county recorder's office, which they're not, which is good, because we don't want, those are public record, we don't want the entire world knowing your trust information and what's included in your trust. So it is private information, and we don't, look at anything besides who can sign, the authorities that they have to sign, how many people have to sign, for the trust to be conveyed, I guess, or how many people have the option. We can leave it like that if you want. So if you run into that hesitation from a client, you can say, okay, we'll need a copy of the trust in order to prove to the title company who can sign on behalf of the trust. Then, and you're met with a no, just turn it over to us and we'll handle it from there and tell you who needs to sign. Because if you have a trust that needs to be signed by, that is required to have 2 successor trustees on it, thank you. And you only have one of them sign, is your listing contract valid? It's not. So it's very important for them to dig into the attic and find those documents. I know it's not what it looks like. And give us all the amendments to the trust and resignations. Sometimes it's very important to get those things after the fact. Competency issues can be called into question. We need to deal with those. Sometimes we're met with no, we don't care who's getting the china, who's getting the Tupperware, we just care who can sign on behalf of the actual trust. Everybody who signs our documents has to sign your documents. That's why we'll want to check and make sure that they're all the same. If the trust states that all trustees must act, then all trustees must sign all of the transaction documents. So if your trust agreement assigns all 7 of them to sign all the documents, then all 7 of them have to sign the listing agreement. If this is where Utah law actually comes in and helps us out. So if you've got a trust and it assigns all 7 of them as successor trustees, and it does not indicate that all of them must act together, then Utah law does say that a majority of them can act. So that's helpful. If you've got 7 of them, they live all across the nation, and the trust doesn't specify, you can have 4 of them act instead of all 7. So that's one area that Utah law does step in and provide some guidance for us. When we're left sort of on our own. So that's sometimes helpful when we have situations like that.
So Kristi, does the 4 that are chosen have to be the same 4 through the whole process? Or can it?
No, they can, yes, they can, yes. Usually we don't really encourage that because it gets complicated, yeah. But it certainly could be, yeah, especially if you have all 4 signing the same of the real estate documents and then a different 4 signing all the title documents, that's fine. But if they switch like per addendums and stuff like that, brokers will have a problem with that because it's changing per contract and that affects, that's.
So the real answer is no.
Yeah, right, yeah, right. Contract.
You could, but don't.
So, but since the title company is not a party to your real estate purchase contract, we don't care. Does that make sense? But your broker will care if you change it halfway through that contract, because contract law says the same parties must participate in a contract to make it valid. Does that make sense?
Yeah.
So we're tapping into different laws, but as far as different contracts, they can be different people.
Yeah, and sorry, one more question.
Please.
So there's, if one of the trustees, let's say there's 4 and all 4 have to sign, what if one of the trustees has passed?
Yeah, then there's usually provisions for that in the trust agreement. If you have a good agreement done and a good attorney who prepares it, they'll have provisions in there. If the successor trustee doesn't survive, then this.
Okay.
If these, if anybody passes, this person takes its place. Or all of these people are successor trustees, there must always be 2. And this is the order in which they go, kind of that type of thing. So there's always, well, in a good trust, there's always provisions that allot for passing of individuals. Usually 2 or 3 lines down the way, usually. If there's not, then you're back to probate, essentially. So, but that's why a trust is done, and a good attorney will help you do 2 or 3 lines down the way. So they'll help you get if then. That's kind of the point. Here's an example for you. This is kind of my favorite story ever, because I was involved in it a long time ago. But and it's sort of comical. I taught this yesterday with my old assistant in the room, and she's like, "This is your family." I'm like, "It's not. I just was involved in it." But very nice, lovely, wonderful brunette eldest daughter. Anyway, younger, so it's just similar. Younger, blonder sister, fine, whatever. Okay, average intelligence, very intelligent, average intelligence. Anyway, and then a little brother comes along and like ruins the entire thing. Okay, like everything was fine and then stupid brother. Anyway, so this is just a family, just an example. Anyway, not mine. Then mom gets up in age and she's living in Heber, Utah in a very wonderful, beautiful home. And eldest daughter sticks around and takes care of mom well into her late age. And other two kids move away. Mother and daughter participate in a lot of community events and lots of charities and things like that. They're very well known in the small town of Heber at the time. Heber's growing, but anyway, at this time they were pretty small and they were very well known. Anyway, so then mom passes away. This is my headstone. I'm getting it ready to go. Anyway, so getting ready to go. And daughter contacts her friendly neighborhood real estate agent, who's a good real estate agent, made a couple of mistakes here, but says, I want to sell the home. This is way too big for me by myself. I want to move on and sell this house. And real estate agent says, well, you know that the property is vested in mom's trust. I'm going to need a copy of the trust. Daughter says, all right, I'll go up to the attic and get you a copy of the trust. But you know, mom, she wanted me to be the trustee of the trust. I'm the only one. I don't know why we're bothering doing this. Agent says the right thing and says, that pesky title company's gonna want it. You and I both know it's just you. Everything's fine. Sign the listing contract. Mistake number one. Sign the listing contract. We'll just market the property, get it sold, no problem. Let's just get things going. The daughter wanted to move out and move on. She didn't want to stay in the property. So daughter moves out, asks for a copy of the trust agreement. Daughter eventually does provide it. It took her like a week and a half or so, whatever. But the house is sold pretty quick, goes under contract. We get the title, or we get the trust agreement. And do we think that the oldest daughter was the only successor trustee? Is that the way it read? How many trustees were there? 3. And did the trust say that they all had to act together? Sure did. They all have to act together. When we told the oldest daughter, this was her response. She was like, nuh-uh, nuh-uh. And I was like, okay, so you were supposed to be the only trustee of the trust. Absolutely, that was mom's intention. My siblings are worthless. My sister moved away. She's in California somewhere. She doesn't want anything to do with this. She's worthless. Well, what about your brother? I haven't talked to him in 15 years. He never even came to the funeral. I don't know where he is. He's worthless, blah, 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 blah. Neither of these two deserve anything. It's all me. Okay, find me an addendum, because the way this trust reads is that all 3 of you have to sign. All 3 of you are successor trustees. Well, that's ridiculous. Okay, well, let me call your sister. Fine, I'll call my sister. This is how the sister reacts. Oh my gosh, I don't want anything to do with these people. How do I possibly get them out of my life? Okay, well, will you sign? She wants to sell the property. Are you okay with that? Yes, I'm fine with that. How can I possibly make this end? I just want this out of my life. I don't want to deal with it anymore. Okay, sounds good. So you're in San Francisco? Yep, I'm in San Francisco. What do you need from me? Well, I'm going to need you to sign some documents, but right now I need contact information for your brother. Oh, I haven't heard from that loser. He didn't even come to the funeral. I don't know where he is. I haven't talked to him in 15 years. Oh, sounds like a lot like what the other sister said. Okay, so we need him. We can't sell the property without him. By the way, property has gone under contract now. We now have inspections being done, appraisals being done, earnest money of $10,000 being presented, and listing agent decides, I'm not gonna tell the buyer's agent that we can't find one of the trustees.
Well, is it even a legal contract though?
No, it's not. No, this is my point. Not a legal contract. And I had this conversation with the agent and she said, we're gonna take our chances, please try and find the brother. I'm like,
Take our chance.
we're gonna take our chances. I'm like, okay. Anyway, so, I should mention she's her own broker. So anyway, so.
Of course.
Just like slide that right in. Anyway, so, okay, I say to this sister, all right, so, do you have any contact information for the brother at all? And she said, I'm Facebook friends with one of his friends. I'm like, cool, sounds good. Send a message to him and say, I have money for your brother, money for him. Just say, money is here, contact me. And she's like, all right, whatever. I'm like, okay, try that. 2 weeks go by. Everything's right on track. We're closing the buyer. Also, lender documents are coming.
Oh,
I'm panicking. I don't know what listing is. She seems calm as a cucumber. I'm panicking. I'm like, we don't have anyone to sign. So and what would have been the solution if we couldn't find a brother? What do they have to do?
So, it's
Well,
valid.
Yeah, the contract, right? But they have to go to court and do like a probate proceeding, basically, which is gonna delay us like 3 to 4 weeks. And interest rates are also going. So I'm asking the lender, so if we can't make our lock deadline, just out of curiosity, so how much is this gonna cost the buyer? Oh, we don't wanna extend the lock. Oh, no, that's gonna cost like $4,500. I'm like, just curious, I was just taking a some just the world right now. Okay, so just thought I'd ask out of curiosity. Anyway, so I'm walking by my front desk and my receptionist is on the phone and she's like, yeah, your name's what? Joey? And I'm like, Joey, I need to talk to Joey. Is that Joey? I kind of leap over the desk. I'm like, Joey. Hi, Joey. How are you? Hey, Joey, where are you? He's like, I am in Chicago. I was like, hi, Joey. Well, I was just recently paroled. I'm like, and let me guess, you're in for 15 years? He's like, sure was. I'm like, cool, sounds good. I have documents for you to sign. You know your mom? Yeah, she passed away. Oh, I had heard that. Okay, oh, good. Okay, awesome. You don't seem real broken up about it. No, I'm good. So what do you need from me? I need you to sign some documents. Documents show up from the lender. We send them out to San Francisco and Chicago via FedEx. Joey and sister in San Francisco sign documents, come back. This one comes into our office and signs documents, not happy, because her proceeds went from numero uno to 1/3. Anyway, so she signs documents, she's not happy. We close the fund and record 1 day before the law expired. Anyway, listing agent was like, I mentioned how much I love you. I was like, oh, my blood pressure's a lot higher now. But anyway, so it happened great, but what could have been the result? Lots of things, right? Like lots of things. These are the things I thought about at night every day for a long time. What if he had said, no, I'm not selling, forget it. I love Heber, Utah. I'm moving back. I wanted to live in that place my whole life. I've been waiting for it for the last 15 years. I'm coming back. Coming home, sis. He could have said, no, thanks, I don't want to sell the property. No, I'm coming home. He could have said, oh, I'm suing you, forget it. I've been researching the values of homes in Heber, Utah for the last 15 years, and I don't think you're asking for enough. Forget it. The buyer's agent, or the listing agent had, it was an FHA loan, and so they had to do chipping paint. It was back when chipping paint was a thing, and so the listing agent had like gone out and painted the property on her own dime on the weekend and stuff. Anyway, so she put a bunch of money into the property, of course. Anyway, I'm sure some of you have done things like that in the past. Anyway, but thankfully, because we kind of persisted and had a good escrow team on it and asked for that trust agreement early on and figured out that all 3 of them needed to sign, instead of just believing the daughter that, and the agent fully believed her too, that she was the only one that needed to sign, it happened okay. So, and thank heaven Joey read his Facebook. So anyway, so it was a little bit crazy. I didn't like that transaction at all. Go ahead.
I'm just curious, if he had still been in prison, could he sign?
Absolutely, yeah, we do it all the time. Yep.
All the time?
Yeah, well, I mean,
You've done it.
fair number of times, yes. Why do you think our home office is in Bluffdale? And I would have to be out by the airport. I'm just kidding. Anyway, I'm totally kidding. Yeah. So anyway, all was well. Joey went and bought a new hog, and I'm just like, this is all fabricated. I have no idea if he did it. Anyway, he just took his money and left. I'm sure they never talked to each other again. Anyway, I fabricated the last part. So this one's sort of the opposite story. This one was an interesting situation where the law actually helped these guys a little bit. We have a daughter who took care of her dad, did not get along with her brothers. So this was a situation of 2 brothers and a daughter. And dad had created appointing his 3 children. He created a trust. He appointed his 3 children as the trustees. Then dad passed away. The trust provision stated the same thing as the Utah law. It said that a majority of the trustees could act. So it said the same thing as law. Even if it said nothing, Utah law would have prevented in this situation. So 2 of the 3 were all that needed to sign. The disgruntled 3rd trustee, which is the daughter, didn't want to sell as proposed by her brothers, and she held out. She wanted to live in the property, and she was living in the property. She didn't want to sell. She didn't want the money. She was a beneficiary. So if the 2 had sold, she still would have gotten 1/3 of the sale of the property. She just didn't want to move. But she went on and described to us and everybody under the sun all the things that she did for her father and that her brothers did not. She threatened to sue everybody pretty much on a daily basis. To her brothers, the real estate brokers, the agents, the receptionists at the title company, basically everybody who was involved in the transaction. And the brothers actually went to court and got a court order approving the sale, leaving her out as the co-trustee. So they didn't need to do that for the sale of the real property. They just chose to do it to sort of make it clean and pretty. I got the impression that they did this to help evict her. In addition to selling the property, but it also helped, sell the property. We just had the two brothers sign. She was fuming mad, she still got her money. On we went. So anyway, but it wasn't required. They just did. Delegation of trustee authority. So Utah law says that a trustee cannot delegate their fiduciary responsibility to another person unless they are also a co-trustee. So if you have, sometimes we have spouses try and do this. So you've got 3 kids that are the successor trustees of a trust, and one of them says, oh, I'm going to be out of town on a business trip. I'll have my husband sign for me. Cannot do that. It must be either they have to sign for themselves and act their own fiduciary responsibility, or they have to give power of attorney to somebody that is also a co-trustee. They would have to give power of attorney to their sibling, not their spouse. Unless their spouse happens to be a successful trustee, which sometimes does happen. It's sort of, we've read a lot of these over the years, and sometimes it's funny how people like their in-laws more than they like their laws. Which is kind of funny, which is fine. So here's an example for you. Sometimes in our state, people like to go on a 2-year vacation. And these guys had decided to do that and had been instructed to go to the lovely country of Argentina. And when they decided to go, they said, we're going to sell our home when we leave, but we're not going to be here to sign the documents. So we're going to give power of attorney to our neighbor, Jack. And he's going to, hopefully it was a different guy. But anyway, but he's going to handle our affairs. Here's our real estate agent. He's going to help sell our house while we're gone. Well, Jack brought in the power of attorney and said, I'm going to help them sell their house. And we said, that's awesome, except they own their home under a trust. And you're not the trustee of their trust, so you can't do that for them. Now that power of attorney worked for like their bank account and anything else that they had under their names as individuals, but anything that they owned under their trust, the power of attorney didn't work for. But in this day and age, it's not that hard to get in touch with people to sign on behalf of their own trust, because they were the only trustees of their trust. Their successor trustee provision didn't take effect yet because they were still alive and not incapacitated. They hadn't resigned, they weren't incapacitated mentally or anything else, and the successor trustees hadn't kicked in, so it was those two, so they were the only two that could sign. So we can find you even if you're on a trek. We have FedEx that can, FedEx and UPS, we can send documents to people. We can send mobile notaries to people anywhere in the world. I set up one the other day for a guy in England, and we were going over the specifics of it, and I was like, no, just keep talking to me about the specifics. He's like, oh, so he's coming to my flat to a certain time. I was like, right, go over it, stand here. It's like, we've gone over this lots of times. I'm like, I know, just keep telling me. I'm going to invite you to tea. Just curious. Again, let's talk about it one more time. Anyway. Awesome. He's getting annoying. I'm like, oh, me. Well, anyway, and we also have something called a remote online notary. Those are really cool. Has anybody used those before? They're cool. So we can remote online notarize people. We've done that for guys sitting in a concrete bunker in Afghanistan. If they are US citizens, they can do a KBA certification, which is a known authorized based authorization system where they go through and answer questions that only they would know, and we can electronically notarize them. So it's a pretty cool, slick little program. So it's great. This is the document. It's not really a power of attorney, but it's called uniform consent that would allow a co-trustee to have another co-trustee sign on their behalf. Sometimes when people are having like major surgery or something like that, it may be beneficial to have a co-trustee sign on behalf of a different trustee when time comes for the sale of a property. So sometimes these are utilized for companies or trusts, any entity wherein fiduciary responsibility must be transferred to a different fiduciary responsibility. If you need this document, I have it available for you. You can send it to you if you find that you need it for any purposes. So our escrow officers call me for that document all the Okay, so, trustees change, original successor trustees, doesn't matter, they can change due to death or incapacitation or resignation. Sometimes people don't die or become mentally, incapacitated. Yes, Jim?
Keyword.
Successor, okay, awesome. So first keyword is tech,
Yes.
second one, tech sigh, just kidding. Second one is successor, I love it, thanks, Jay. But it doesn't matter if, sometimes people just are mentally fine and they aren't dead, they just don't want to be the trustee of their trust anymore, so they can resign, and just say, no, I don't want to be the trustee of my trust anymore, and then the successor provisions kick in, and the other people that they've designated will take over. So that's a very plausible option if people are nearing that point in their life where they just don't want to be the trustee of their trust anymore. So we've seen that happen before. The key for us in our industry is to make sure we are dealing with the correct trustees who sign our documents, so our documents are valid. We care about. This is a normal breakdown of how a trust would look. We have Jack and Jill as the original trustees, then if Jack dies, typically Jill would act on her own, not always. Sometimes you'll see a successor trustee step in with Jill and act with her, not always, but sometimes. Or Jill acts on her own, then after Jill dies, then two successor trustees would take over. Most of the time people assign two successor trustees, not just one, so that the decisions can be made jointly and one person doesn't run the show. So it's pretty normal. Mental capacity, like my picture, that is awesome. We have neighbors that are trying to move and I'm always like, and we're threatening to do like weird things every time the house is shown. We're like, I'm just gonna sit outside with weird stuff on. Yeah, we're trying to like make it so they can't sell.
So this is more of your family.
Yeah, this is like my own. Yeah, anyway, just kidding. But anyway, they if we're calling into question, sometimes the removal of the original trustee is due to competency issues. So typically the provisions inside of the trust indicate how to identify that. Most standard trusts will say in there that you need to have a letter from two physicians that will identify how to deem that that person is incompetent. We actually had a trustee or a trust done not very long ago, but the woman was very nervous about being identified as incapacitated when she wasn't incapacitated. And so she put a provision in there saying that I have to be determined incapacitated by 3 different doctors, and it has to be this doctor in Salt Lake, this doctor in Richmond, Virginia, and this doctor in Seattle, Washington. So not only was it not 2 doctors, any doctors, it was these specific 3 doctors in 3 different cities across the nation. Now that sounds great and good. Oh, and they had to get together and they had to agree. So, and it sounds good. You're like, she was just really worried about being deemed incompetent by her daughter when she really wasn't. So, and everybody thought this is a good plan, except for the fact that there was a lot of pitfalls in that. The attorney that presented and created this trust agreement only went that first step, because what happens if those doctors are out of practice, if they don't practice anymore, heaven forbid they retire or die, what if she can't travel to Richmond, Virginia or Seattle, Washington to be seen by those doctors? What if those doctors refuse to collaborate? Because doctors love to collaborate with people they don't know for one specific patient due to a document that wasn't prepared by them or approved by them. Anyway, so there's a lot of sort of things that could have gone wrong with that. It actually worked out that she was able to travel to be seen by all 3 doctors. All 3 did agree to communicate with each other. The 2 that were out of Salt Lake deemed that she was competent. The one in Salt Lake said that she was not. So she was able to sell her own home. Her daughter didn't have any say about it. So anyway, but it was interesting. But there was a lot of potential there for failure, which would have meant it would have went to probate. If any of those doctors had been out of practice or unwilling to cooperate or anything, and it would have gone to probate, her daughter would have been her executor anyway. So it was sort of a good idea, but it didn't get like executed correctly. So anyway, but most general trusts will just say 2 physicians of any kind, can deem me competent or not. Self-dealing by a trustee. Sometimes people worry when they appoint only 2 of their 7 kids that those 2 will just take the property and leave out the rest of the beneficiaries. Sometimes beneficiaries worry about that, like, oh, you're gonna just take the property and run away. That's called self-dealing. That is not allowed. If that ever happens in a situation, beneficiaries have a really, really good court case against the trustees, and courts don't like that. So, that they would be heavily penalized for violating their fiduciary responsibilities in the court, and they get penalized greatly for that. So the beneficiaries would reap their funds back, and probably big penalties against the violating trustees who did that. So that's not really, shouldn't be a concern for someone, because if they did, they get in big trouble. So, okay, that's it for trusts. Any questions on that?
Can you remind us what the difference is between revocable and irrevocable?
I was gonna
Hmm.
say. Yeah.
Yes, one can be changed, one can. Yeah, it's not easy. Irrevocable trusts are typically used in situations where the trustee is not a family member. It's typically an attorney, it's typically an outside person. It's typically done when beneficiaries are minors and trustors are either not capable of managing their own affairs or no longer wish to. Typically, irrevocable trusts are done for trust fund kids and things like that, where it's being established long-term and they anticipate no changes to be made ever. You can get a little tricky with those, meaning that it's generally for estate planning purposes, it's better to do a revocable trust, because then you're in charge of your own world. An irrevocable trust is just that. It's being set up for the future. It can never be changed. That's it. That's why it's managed by an attorney, a firm, a bank, a charitable organization. It's usually managed by an entity or an unrelated party. If that makes sense.
Yeah.
There was an irrevocable trust one time that was set up. I think it was an accident, but mom made her daughter the trustee of her trust and made it an irrevocable trust. Mom wanted to sell her house. Daughter said no. And said, no way, I need you around to babysit my children. But she wanted to get married and move to Mesquite with her new husband, and daughter said no. And she just up and moved in the middle of the night and left anyway. So then daughter had a vacant home. So daughter was like, oh, lost my babysitter anyway. So apparently you can control their assets, you can't control their mind.
Yeah.
And their love. Anyway, so yeah, irrevocable trusts are for a purpose, but typically used for asset protection and for managing of financial assets, not like liquid assets. And in addition to real property, but also liquid assets and the managing of those. Okay, I think that's it. Let's move on to tenancy and probate. Okay, joint tenancy. You guys have heard of joint tenancy? It's been around for a little bit. Typically, to create joint tenancy on a deed, we need to see the language of as joint tenants with full rights of survivorship or to the survivor of them. Doesn't need to say all those. Sometimes we see as joint tenants with full rights of survivorship. That's just duplicate. You don't need that. In other states, we need both. Not in Utah. In Utah, you can have one or the other or the other. For any deeds, as we're talking about conveyance deeds, warranty deeds, stuff like that, dated after May of 1997, a joint tenancy was automatically created by putting in the verbiage husband and wife or wife and husband. If it said wife and husband or husband and wife, it automatically created joint tenancy. So if you had Jim and Sally, they automatically, and it said husband and wife, they automatically had joint tenancy without saying as joint tenants. Then, some laws were passed in May of 2022, and they changed the language to say spouses because of federal regulations. So this got a little bit confusing, and it changed things to now husband and wife is no longer implies as joint tenancy, because now we have wife and husband and husband. So now it's not sufficient enough to just indicate marital relation. It needs to say the phrasing with rights of survivorship or as joint tenants or to the survivor of them. It needs to indicate one of these three things after it. This language right here is no longer sufficient. Does that make sense? Anyway, so we as US Title, we just always on May 4th of 2022, we just decided to change our policy where we always say it may indicate their marital relations, but it also always says as joint tenants unless instructed not to. It's just too risky to obligate people to probate if they don't wish to be subject to probate. Okay. Anyway, so very cool stuff. I like how that's progressed through the world. But states around us are very different. So it's pretty interesting how different we are from Colorado. Colorado, it's much different. You have to have a lot more language in there to imply joint tenancy than us. So we're pretty loosey-goosey. When a joint tenant dies, his or her interest in the real property automatically transfers to the other by operation of law. You probably know, but all that's needed to be recorded is a death certificate. The interesting thing is that many people don't understand is that the items attached to the property that were attached to the deceased party also transfer to the other person. So if you have a judgment against the deceased party that is against that property, when you take title to the property from the other person and get sole ownership of the property, you also get that judgment. It does not go away. Just like if they were to sign off of title, that judgment remains on the property. So does when they were removed via tenancy and a death certificate, the judgment also remains on title. The only time I really have seen this be an issue is with healthcare companies and hospitals. Because they'll have a judgment against someone being treated for a terminal illness, and then that judgment gets filed against them, gets attached to a real property, and then the person dies from said terminal illness, and then the judgment or the ability to collect on the judgment is not applicable because the person is deceased. However, the hospital is very aware that the judgment is collectible against the real property that deceased party used to own with their spouse. There's no political statement on that. Dude, I'm so political. Never thought of it. Also, even though there's an automatic transfer with the deceased tenant's interest, it should be, and years ago it used to be that we just would record a death certificate. Counties in, at least the major counties in Utah have changed it, that they now require us to tell the story. So we have to record an affidavit now. It's not required by law, but it's required by the major counties. So now we just do it everywhere. So we just recorded an affidavit saying this person who is on title to the property is the same person that is on the death certificate. They're the same, they're one and the same, which is helpful because death certificates typically have somebody's full name, especially with women and married names and stuff like that. And then they may be on title with just a middle initial or sometimes even slang names and stuff like that. So sometimes you'd be surprised how people are on title. Their on title is Bubba, but their real name's William. I'm like, of course. Anyway, the loan under Bubba. Anyway, you'd be amazed how people do these things. But anyway, especially up north. Our friends in Tremont. I'm like, the farmer got a loan under Bubba? And they're like, yeah, sure. Anyway, it's awesome. Anyway, I'm like, what's this letter? Anyway, basically it's important for, I used to say that all of this stuff was a manila folder, but my escrow manager would tell me, we are a paperless company, we don't have folders anymore. So I'm channeling her. So it's all in the computer now. But it's just important for everyone to know that when we're dealing with a deceased party, only because, and as soon as possible, because sometimes, and Kristi can attest to this, we've called up clients and they've told us, I'm the executor of the estate, right, Kristi? How many times have you heard that in your career? Thousands, right?
That one was a little bit of a mess, but we figured out.
We got to figure it out, I know. Well, I'm the executor of the estate, kind of means nothing to us. It could mean that they're the trustee of the trust or the successor trustee. It could mean that they've gone through probate and they have the documentation needed for letters testamentary and we're good to go. It could mean that they have a will in, you know, that they've drug out of a box that says, I want all of my stuff to go to Freddie, and we're talking to Freddie, that hasn't been probated at all. It could mean that, you know, on mom's deathbed, she said, I think you should handle things, I no longer like Billy. It could be that. I mean, there's a bunch of different things that people interpret as I'm the executor of the estate. And we sort of need to translate that as being as possible in the transaction, because sometimes it will require a court, process or motion to be in front of a judge. And that can take some time and slow down your transaction. So we want to handle it as quickly as possible so we can prevent those things from slowing down things.
Did you change it? Find my Zoom. Just
Leave it
leave
there.
it there.
Fine, I was gonna say, let's just leave it there. No.
But you, oh, you go to different
It's okay.
side.
Yep. Let's go down there. I wish I had it more memorized. That one wasn't.
Flip. Weird.
That's true.
I have a question for you.
Go
real
ahead,
quick.
please.
So. What you were kind of just recently describing is what's going on with my husband. Well, like years ago, his parents were like, "You're the executor," and he's like, "Okay, do you have a will? Like,
Yeah,
what am
what
I
does that
an
mean?
executor of?"
Yeah.
Yeah. Anyways, his mom passed and his dad is not really mentally all there. Like, how can he find out without if there is anything, if they don't communicate to them or haven't.
That's funny. Isn't that funny how parents do that?
I know,
They're
and
like-
he's got 6 siblings and they will not cooperate, and he does not want to be the executor, but if he is,
Great.
anyway.
That's interesting. Okay, does he know how do they have, just their home, just their assets is just their primary residence, right?
And they've got a reverse mortgage on it.
Okay, so number one, about just side comment about the reverse mortgage, is that a lot of people think, well, the bank owns my home. That was the number
Right.
one statement. The bank owns my home anyway, not true.
Right.
They own their home. The reverse mortgage requires that they live in the home, they have to occupy it. If they don't occupy it for 60 days, then they have to, sell it, or, just they. they have to
Finance
sell
it
it.
or whatever.
So anyway, so they, but do you know how they're on title to the property? Do you know how they own it?
I was just thinking, I'm gonna go
Yeah.
check that
You should find out.
this afternoon. Yeah.
Yeah, because that'll matter a lot.
Yeah,
Do you know if they have a trust?
I don't think they do.
Okay, that's okay. It's probably not
I don't think they
earth
have a
shattering.
will.
They may not need to. That's okay. It's not the end of the world. The only problem is that if you end up in probate with them, because they don't have a will, which is okay. Even if they had a will, you'd be going to probate. It
Yeah,
just makes it
right.
easier. They, the probate can be contested. So if
Yeah.
you've got siblings that might fight it, or might object, or might want to be the personal representative for that estate, that may create trouble for you.
Yeah,
Does that make sense? That is what I would mostly worry about. If they might be able to do a Todd read. If you can convince them to. They want to do any estate planning or.
yeah, I've talked to them about it and they're like, yeah.
They're like, it's your problem.
Yeah.
Right, we'll be
I'm
there.
like, well, this means nothing for my husband that you want him to make the decisions, he won't be able to. Anyways, I know it's gonna be a massive headache soon in my near future.
It's interesting how they just say, okay.
Yeah.
But if they aren't willing to do anything, I suppose you prepare yourself
Yeah.
to do probate and hope that it's not contested.
Yeah.
The problem is that probate needs to be paid for, and you have to sort of have someone willing to front the money for the probate, and then you can get reimbursed from the estate, but it has to be paid for upfront.
How much is it usually?
Depends if it's
there may be a loss, he will charge it to and be paid at closing.
she'll wait for the property to be
Yeah,
sold.
just invoice you and you just pick it all up at closing, I don't know whether she does.
That's good. It's usually, if it's uncontested. Kristi, do you know Jennifer's price? It's probably between two and.
The one that, it just depends on, I've seen him at 2,000 and then that one where we had to go.
The emergency one.
Emergency one, that one was like $5,000,
Yes.
yeah.
I usually say between 2 and 3,500.
Yeah.
But if it's contested or an emergency, or something like that, it can go up to about $6,000.
Yeah.
Normal. So, but see, a trust can be 2,500, something like that, especially if it's an easy trust. So, it's a good, and then you don't have it be contested. The trust can't be contested. It just is what it is. Mom and dad died before they pass away.
Okay, so open the file. Weird. Maybe connect back to Zoom and just don't even worry about that. We'll survive without the screen.
Okay,
Just share your.
So we can watch my computer.
It's weird. All security features you have corrupted the file.
It's so weird. It's the same.
I haven't missed any passwords, have I?
Just two,
Yeah.
tech and successor.
Successors. Oh, I wrote those down. Then you said resign, so I wasn't sure if that was part of it.
No, just those two.
Okay. Okay.
Sorry about this, guys.
All right, you guys can hear me okay? Hopefully. This is what I'm showing. Yeah, it's fine. Good. I'm gonna just go with it. Jen, are you watching that chat?
Yes.
Thank you. Okay. Okay, I know it's yucky, but we're gonna proceed like this. Okay, so let me just give this example right here. Okay, this example is sort of interesting. Okay, this one is a oh, I'm sorry. This one is an example where we sent hopefully this does not freak out. And it did. Jen, you see a black screen, right? Okay. Okay, there we go. Okay, so now, okay, just do this. Okay, we had a transaction in our Park City office and we mail out documents for that all the time. And we sent documents to the client. We talked to him on the phone a whole bunch of times. And he kind of confirmed that he was going to go to a local notary there and get the documents signed and send them back. We had everything all confirmed and ready to go. And and we talked to him several times on the phone. We sent him the warranty deed and he sent it back to us. Our Park City office gets the documents, they open it up, and they have his signature on there, and where his wife was supposed to sign, he had just written RIP. We're like, okay, RIP is not okay. So apparently his wife had passed away and he didn't tell us. We were like, what? Oh, hang on. Well, that's not okay. Anyway, it was sort of silly. We were, oh, geez. Anyway, so we all just kind of went, oh my heavens. And the agent had sent us their documents as well to be included in the mail out to have his wife sign as well, because she didn't have him sign anything with it. So she wanted those things included by his wife, and he wrote RIP on all those too. So the agent didn't know that she was deceased. We didn't know she was deceased. We just thought that hubby was sort of handling everything and that she would participate with him. And anyway, we got the documents back with RIP written on them. So that didn't work. We had to inform him that that was not okay. And they were in title as tenants in common, which means what? It means that probate. Yeah, very good. So the entire transaction was delayed by several weeks because we had to go to probate. So anyway, which he was completely shocked about. He was like, "Oh, I thought I could just write RIP on the documents." Anyway, yeah, if it was joint tenants, we would have just recorded a death certificate. So yeah, that was sort of the bad thing. But he lived in a state where tenancy was a little different, so it was quite confusing for him. So poor guy, that was kind of a bad thing. This one is, we're just talking about tenants in common. So a lot of people think that tenants in common, the way that he and his wife were on title, is a bad thing, and it isn't necessarily. We will default to joint tenancy whenever we can, just because it's a nice way to take title for married individuals. And we don't ever want someone to go through probate if they don't have to. When it's silly, it's obvious that it should go to the other party. That's obviously their heir. But there are many times when tenants in common is beneficial. Like if you buy property with your parent or your sibling, or you're like my sister and you deed every boyfriend you've ever had onto your house. I'm like, oh my gosh. Anyway, and then your sister has to track them all down and get them to deed off of title. I'm like, oh my goodness, stop doing this. Anyway, so so there's many times when when tenants in common can come in handy. If I were to buy a property with my mom and we both went into the property 50-50, and then she were to pass away, I'm pretty sure that my siblings would have a problem with her interest in the property going directly just to me. They would want, their portion of her 50% of our investment. That makes sense. So that's a situation when tenants in common can come in really handy. There are also a lot of people will say that if you're entitled with entities that you're entitled as tenants in common, it's a little misleading because tenants implies individuals. So if you have two companies, they're not as tenants in common because entities can't die, but they're in 50-50. Does that make sense? So that's kind of what that means, is that they're not, one won't flow to the other if one ends. So anyway, but tenants implies individuals. If you just have one person on title, you're missing my really awesome photo of a guy by himself sitting with the birthday cake on it. Anyway, when one person is all by themselves, they are the only person, or if they're the remaining person on title. So if there's just, they were in as joint tenancy, and then that works. Yeah, thanks. If they weren't on title by themselves and then or as joint tenancy, and then one person passes away, they're the sole person left. That's it. After they die, some of their heirs are going to have to go through probate for them. So that's about the only way to do that, unless they set up a trust just for themselves, which they can do. Or another option, which we're going to talk about in just a second. When a tenant or a sole owner dies, the interest in the property doesn't automatically transfer to another person. In other states, it can, based upon just a will. In Utah, all wills must be probated. If you have the best will in the world that says, this is my property, this is who I am, this is who I want it to go to, this is their full name, I've specifically disowned this person, which we see in trust all the time. We see people specifically disowned and specifically left out and specifically, not acknowledged or whatever. Even if you have all of that, it still must be dealt with in a probate court and signed off on and stamped by a judge. So, what was I gonna say?
On a time frame that is usually
Depends. Okay, so there's two different, this is exact, thank you for the lead in. Over to you at the news desk, Jack. Anyway, that was perfect because that was awesome. If a tenant in common or sole owner dies, and they die, they have a will and the probate is, probated within 3 years of death, then they, do, a regular probate proceeding and get a personal representative assigned, and they get a document called letters testamentary. And they actually, in that type of a transaction, they actually use the letters testamentary to get assigned a personal representative. And typically the judge will say on that document that the estate division is unsupervised. So they don't usually monitor that. It's very rare for them to monitor a personal representative. And then that personal representative does this personal representative's deed directly over to the new buyer. If for whatever reason, we have a lot of people who get that personal representative appointment, and then they want to take the title from the property and take it from the deceased party, from mom, let's say, and they want to deed it to themselves and then deed it to the buyer. There is no need for them to do that. Encourage your clients to not do that. There's no need for them to do that. They take on tax liability. They sign up for any judgments that they have against them to attach to that property. They take on tax liability. There's all kinds of stuff and reasons for them not to do that. So they can go directly from them as a personal representative acting on behalf of the estate directly over to the buyer. And that's how we want it.
Would that also affect the 90-day rule that they take?
Yeah, definitely. It certainly would. Yeah, absolutely. And there's just no reason to do it.
Yeah.
It's weird how people, there must be something in that court proceeding or in that their attorney tells them or something, because almost everybody who walks out of there with the letters testamentary says, okay, I need to deed it into my name. I'm like, no, you don't. No, you don't. Please don't. Yeah. So, so I'm not sure why, but if they ever ask you about it, please don't. Anyway, so the will happens within 3 years of their death. If they have a will and the probate is done within 3 years of their death, then they get a letters testamentary. They do a personal representative's deed into the name of the new buyer. If they die intestate, which means they have no will or it's been longer than 3 years, then it's called intestate succession. And then they do a decree determining heirs. A decree determining heirs is a different document wherein the court gets involved and they basically do more direction. They sort of say, okay, these are all the heirs of the deceased party, and this is how the funds should be distributed. This is how the breakdown of the assets should be distributed. So unlike the personal representative's deed, they'll just say, this person is the personal representative and it's unsupervised. The decree determining heirs will say, this person is in charge and this is how it should be distributed to all of these heirs, kind of thing.
So basically just have one.
Pretty much, there is no will. That's why that's why they do this, is because there is no will. The other one, there is a will and it's been within 3 years of their death. So even if this one, they do have a will, but it's been longer than 3 years, they'll still like give direction. Does that make sense? So either or. So we either have with the will and within 3 years, it's personal representative, or longer than 3 years and no will, it's decree determining heirs. One of the two. And both of them work for transferring title directly over to the buyer. You don't have to. The decree determining heirs also, you can petition, when you file that petition with the court, you can have your attorney ask them to appoint a person to act on behalf of the heirs, and most do. But if your attorney doesn't, they'll make all the heirs sign, which is cool. So anyway, it just depends on your probate attorney that you're using. So. So this is just showing an example, if you can see it on the screen, but it'll say like, if the person A died in March of 2017 and they have 2 kids and one is living, the court will actually indicate on that decree determining heirs that the proceeds should be distributed into 2. But if the one child died before the mom, then that child's inheritance would go to their kids, and it'll indicate that right on the decree determining heirs. It'll break it all down right on that actual document. The other thing is then that becomes public record. So that's the other thing that people don't really like with the decree determining heirs. Reason to do probate within 3 years of people dying. So. And to have a will. Mom and dad have a will. Just kidding. Yeah, this is just saying they could have someone appointed. Also, this is just talking about how the probate is a process where people can contest it. So probate can be initiated by anybody. I always say that probate is initiated by the person who has the money to do so, and who usually it's initiated by the person who wants to be the personal representative. Typically, I have seen it done where it's like initiated by someone who had the money and they say, I think this person should be the personal representative, but typically it's done by the person who wants to be the personal representative. Or one of two or something like that. But if it's contested, it can take a long time and you get into a battle, just like a divorce or anything else, where you're battling in the court systems back and forth on what should happen with the estate. I've seen a probate take 8 years to finish because people liked battling. The attorneys won out really well on that one anyway, but it was like becoming a hobby for these people to battle over this estate. So I don't think anybody won on that one, but anyway.
What exactly do you have to do to initiate probate?
It's a court filing. So you meet with your attorney, they write a motion, it's like a 2-page motion, and just petition the court and say, this person died on such and such date, this is their kid, you know, they were married to this person's now deceased, you know, this was their second marriage or whatever, this person's now deceased, these are their children that they had via birth or adoption, this is, you know, their kids and who they're married to and blah, 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 these are all their heirs. They do like a family tree kind of thing. And then they petition the court and say, this person should be the personal representative because they are, you know, competent and able-bodied human and the best representative for the family, blah, 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 here's why. And here's the accompanying will that backs up our claim. If you have a will, if it's that type of a probate process. And then the judge says, oh, yeah, it's good. That's it. So I've actually done probate for, you don't have to be an attorney to do it. I've actually done probate for a client. No, I will not be doing yours. I did it one time for a client whose dad had passed away first, then mom had passed away, then her brother passed away, and it was just her. And she needed it for one piece of property. They had already handled everything. Everything else was in the trust except for one other piece of property that they forgot to put in the trust. And so she needed a dumb little probate done. And she's like, it's just me. It's me, and me. Like there's no what's left. There's nothing. And mom had a will, and it said, I have one daughter, everybody else is dead, like this is my will kind of thing. Like it was the easiest thing ever. And so I filled out all the paperwork for her and she signed it all and everything, and she took it into the court and gave them the paperwork, and the court clerk looked at it and said, go sit over there, don't leave. And she went over to the judge, and the judge stamped it, and she gave it back to her and said, oh, that was the easiest one ever, and gave it back to her. She was like, holy moly. And I was like, anyway, it was cool. So, but that's really rare. You know what I mean? Like that was like, we just happened to be like.
I guess I'm just wondering if people ever just go and do it themselves.
They do. Yeah, that's what we did. Yeah. You can do like this simple probate. Yeah, happen all the time. Yeah. Absolutely. You can do a simple probate. Yeah, that's kind of what it is. So you kind of just like list, you know, these are all the people. This is all there is.
Right.
This is what we want to do. Is that okay with you, Judge? And the judge says yes or no, get an attorney, you know what I mean, or whatever. So it just kind of depends on the situation. So yeah, I was amazed it worked, but whatever, it worked. So because we were kind of like not at a loss if it didn't work, you know what I mean? We were gonna, she's gonna hire an attorney anyway if it didn't. So I was like, let's give it a shot, shall we? I must have had a lot of free time back then is all I can figure. I don't know. Anyway, I don't know why we decided to do that. But anyway, there's also no probate shortcuts. Like there's not a way to say, in other states, you can say, I have a will, and therefore that allows me to act on behalf of this estate as their executor and sell the property. That's why people say I'm the executor of the estate, is because that works in other states, not in Utah. There is no probate shortcuts in Utah. Every will must be probated. So a lot of times people do not understand that, especially if they don't live in Utah. We spend a lot of time on the phone explaining to people outside of the state that even though you have a will that's beautifully written and well done and done by an attorney out of New York, it doesn't matter. The probate must still happen in order for you to sell the property and get in line, because it's just dependent upon how long it takes for the court to look at your probate and approve it or not. So that's it. This one is just talking about how as soon as you know about it, let us know, and then we'll get to work on whether or not we need to get probate done or not. So because we can help you. Kristi does have that. Jennifer did an emergency one for us one time because we were acting it's actually conservatorship. It wasn't a probate, but it's a very similar process because we were acting on a power of attorney. I'll come back to that in just a second because we do deal with power of attorney at the very end of this. But I want to talk about the TOD deed, transfer on death deed. These are brand new. The legislation was passed in 2018 that allow people to do a transfer on death deed. You have to do it when you're still alive. But if you have only one person on title, it cannot be two people, it just has to be one individual on title. So not a trust, not an entity, just one person. You can record a document, it's a revocable or irrevocable, called a transfer on death deed. And when you record it, it simply indicates who the vested owner is. And it says, upon my death, I designate the following primary beneficiary. If they survive me, please put this person in title after me. If they are not alive at that time, here's my second alternate beneficiary. Please put this person in title afterwards as a second beneficiary. And that's it. Then you sign it and notarize it. That's it. So I sent my little single, I say little because she's like 4'8", like she's super tiny, and over to Jeff Scobie to get a trust done. She lives by herself. She has one son. And she just wanted to put her house in her trust. And I said, talk to Jeff. And Jeff sat down with her and he said, you don't have enough assets. You don't have enough like need for a trust. You just want to give your house to Paul when you die. And she's like, yeah. He said, let's do a TOD deed. So they did it. So instead of costing her, $2,500 for a trust, they did a one-page document, cost her $500. So I really liked that, that he gave her the option of what was truly best for her, because these are so new. Now this TOD deeds are so new that we have we have 9 underwriters, but we have 3 major underwriters at US Title, and 2 of them will insure TOD deeds that involve TOD vesting transactions. One of them will not, because there's not enough case law on them, on whether or not judgments attach to this. They're waiting for more case law to happen. I only know of 3 transactions that we've had where people have recorded TOD deeds, passed away, and the successor beneficiaries have actually taken title to the property and then sold it from there. So we've only insured 3 of them that I know about as an agent.
It's recorded right on the property.
Right on the property. Absolutely. Yep. It's in the chain of title. So. Yeah, there wouldn't be multiple TOD deeds. There should only be one.
Like multiple properties.
Oh, yeah, right. Sure. Yeah. They have several properties. Yeah, they want to do it one on each one. Yeah, absolutely.
Helps not protect them from having to pay taxes.
Correct. Absolutely right. You mean, yeah. Are you talking, well, what kind of taxes? I'm sorry.
If they were.
Property taxes.
Sell it,
Mm-hmm.
it would not protect them, but if it was in the trust, it would protect them.
It would be estate taxes under the trust. It would be, it would still be estate taxes under the TOD. Yeah, it would. It'd be okay. Yeah, and they wouldn't have the problem of the capital gains from when the TOD deeds was recorded. They would only have it from when they go into title. So it'd be good. Yeah, it'd be okay. Same as the trust. You're right. It'd be good. That's sort of what it was designed to prevent, because we have a situation very similar to yours where a guy puts his daughter on title who, as an estate planning plan, and then finds out his daughter has a judgment against her for $23,000 for a car I forgot to pay for. Oops, sorry. And then goes to sell the property, finds out the judgment's on there, deeds his daughter off of title, which is lovely, except for the fact that the judgment is still there. Was counting on that $23,000 as his down payment for his new purchase. That's gone. That went to the car judgment company. Now he can't buy his condo that he's already under contract for, that he doesn't have down payment for. So yeah, bad news. Thanks, daughter. Anyway, so yeah, that's kind of the same type of thing. The TOD deed would have been the perfect thing for him at that time, but it was like in 2007, didn't exist at the time. So anyway, so that's a brand new thing. They're kind of awesome. I think they're going to take off really like a lot. A lot of people will use them because they're just so simple. But the only trouble is that they don't work for 2 people. So it's only valuable for people that are on title just by themselves. So if you've got a husband and wife, it doesn't work. Anyway, but if you've got a husband and wife in joint tenancy and then one passes away and then you've got the remaining spouse on title, then it would work at that point. So you could have mom or dad execute one after the other spouse passes away. So there's an option for it. As long as they're competent, they can do that. So. Yep. Yeah. $20, we're gonna be asked to be creating those, huh, Kristi?
I haven't had one, so I'm curious.
Guess what I have in my hard drive? If I can get it to pull up. Anyway. Also, competency issues can be called into question in probate. That's sometimes why a probate is contested, is that you'll have a will that is signed and then that will be probated, and then you'll have a sibling or a prior spouse or something like that, stating that when the will was signed, the person who signed it wasn't competent. That is what most contested probate issues stem from, is when that will was executed, were they competent at that time? Were they talked into signing that will or the addendum to the will or whatever the case may be? So that's sort of why probate gets a bad name, is because it can be contested. Trusts cannot be contested. That's why. So that's why you would want to push family members to do a trust as opposed to just letting them do a will.
And it doesn't matter how much.
No, it doesn't matter. Yeah, it doesn't matter. If they are deemed incompetent, a conservator must be appointed. This is what Kristi had to deal with a little bit ago in relation to a power of attorney. Let's talk about that just a little bit and then we'll be done. Power of attorney is a document where we take the principal, which is the originating person, and they give power of attorney or create an agent, not a real estate agent, to act on their behalf. So, and most of them are general or special, which indicates a specific purpose for them. How long does a power of attorney last after someone has passed? Thank you. I'm trying to get the word out, please. It doesn't last after they're dead. We had a transaction a while ago where the recording at the county recorder's office using a power of attorney was dated, or was timed on a Friday afternoon at like 4:42 is when the recording happened, because we had the time on it, and the death certificate was 5/12 of that same date. I was like, holy moly, that's really, really close. And we don't ever want to do it that close ever again. We've been on the phone before with people in the ICU. We're like, still alive? So, okay, go ahead and record. Okay, still alive? Okay, still alive? Okay, good. You know, I mean, it's just like, as soon as they pass, that power of attorney doesn't work anymore. So it's very important that we sort of understand that and use that. If we're presented with a power of attorney and they're competent, we will call and make sure that the principal is still okay with that power of attorney being used and that they're still. So it's kind of important. Jen, let's say our third word. Yeah, go ahead.
Yeah.
I was gonna say power of attorney. Sounds lovely. Okay, there's a certain kind of power of attorney that is more preferable than others. It is called a durable power of attorney. Durable means that it survives incapacitation. Now, lovely power of attorneys will say durable right at the very top, and we go, yay, that's very helpful. But a power of attorney can be durable even if it doesn't say durable at the top. It just needs to have a provision somewhere inside the document that says this power of attorney shall not be affected by disability of the principal, or similar words like that. Just needs to say that somewhere in the document. That makes that power of attorney durable. This is the exact situation that Kristi was dealing with. She had a client that was alive, but incapacitated mentally. And they were selling several different properties. The first one came ready to sell, under contract, listed, under contract, ready to go. They had taken the power of attorney from the Utah code. If you look up power of attorney online, code of Utah, it seems very legit, right? Where else would you get it from? I've seen the form several times. A lot of people use it. They had it notarized a long time ago. But not too long ago, anyways, a little bit ago. And then they were planning on using that for the transaction. Nowhere in that document did it say it was durable. And now our party was incapacitated. So the problem is that power of attorney is not valid. So they had to hurry, and it was like, 2 days before closing. So they had to hurry and go to the court system and get a conservatorship appointed for that incapacitated person. If they had simply put in a sentence that talked about how this power of attorney isn't affected by incapacitation of the principal, then that power of attorney would have worked for all their transactions, would have saved them the court proceeding of $5,000. So like 2 sentences. So they saved some money by doing their power of attorney themselves, but they didn't really save themselves some money in the long run. Plus, the durable power of attorney is very helpful because Mental incapacitation doesn't happen overnight usually. Doesn't happen that you're fine one day and then you're not fine the next day. It's usually a good and bad days type thing. Durable power attorneys are very helpful for that because it says in there that it doesn't matter whether you're capable or not. This power of attorney works for both of those scenarios. I don't know if you guys can see this, but this is an example of a power of attorney that did not work. This power of attorney is one of those generic type forms. I used to say that you'd grab this at Staples, but that doesn't really happen anymore. People go online. But it says at the top that it's just a power of attorney. Then it's got a bunch of blank lines on there. And if you initial the bottom one, it says that all of these powers are granted. So real property, financial, all that type of stuff is all valid because they initialed the bottom one. Then there's a sentence right at the very bottom. It's super tiny, so I enlarged it for you, but it says, this power of attorney will continue to be effective even though I become disabled, incapacitated, or incompetent. Right there, that sentence makes this a durable power of attorney, even though it doesn't say durable at the top. So this is great. So Georgiana gives power of attorney to David, and it is durable. So it means that no matter her mental capacity, she can, David can sign on behalf of Georgiana. And it was signed in February of 2017. Then she passes away in July of 2020. And then David records a deed from Georgiana because she owned a property by herself. And it says, this deed says that Georgiana signed by David using this power of attorney, deeds title over to Georgiana and David as husband and wife as joint tenants. Why would he want to do that? Why would that be beneficial to him? To take a property that's just owned by Georgiana and deed it to both of them as husband and wife as joint tenants. She did die. She did die. Because joint tenancy means that he can record a death certificate and then he'd be the only one entitled and he could avoid probate, right? That's why he wanted to do that. The problem is that he recorded this in August of 2020. When did she die? July of 2020. So she had died the month before. So that power of attorney that he had wasn't valid. It was invalid at that time. It's also self-dealing, which is why it doesn't work for the title people in the back. But anyway, there's a couple reasons it doesn't work. But anyway, but nice try, David. It doesn't work. So that power of attorney was null and void in July of 2020 as soon as she died. So he had to go through probate because she was the only one entitled to that property. Chances are through that probate proceeding, they made him the personal representative and then he was able to sell the property, but he had to go through that probate process. One last thing, and then we're done. For a period of time, I had like 3 different clients deed their minor children onto title to mess with ex-spouses. I have no idea why. This is the weirdest thing ever. So they're going through a divorce and they decide, I'm going to put on my 11-year-old on title because that's who I want to get the property anyway. I'm going to put him on title now. Great idea, not. So do you just wait for 7 years until the kid turns 18 and then have them sign off? No, you don't have to. You can, but you don't have to. If a minor is put onto title, they cannot execute a contract until they're 18. So you have to have a conservator appointed for them, which means another court proceeding, which hence the reason causing trouble for your ex-spouse. So don't be mean and do that. But if anybody, if you want your minor children to be the beneficiaries of your house, do a trust. They can be the beneficiaries of your trust and be minors and still not enter into a contract because the trustees will be of age and can enter into contracts. Okay. All right. Any questions on anything that we went over? You say it's why my computer doesn't work. Yeah. That I don't know. Okay. Okay, you feel overwhelmed?
Anybody on Zoom have any questions? Comments? Wow, we made it.
Okay, we're gonna have you text in the keywords. The first one was tech, second one was successor, and third one was power of attorney, which is technically 3 words. I know that bothers me because I'm an OCD person, but it's okay. Jen will let it go. Oh, nice. Thanks, Tanner. Oh, perfect. Tanner, come up here because then people on Zoom can see your face. Yeah, Jen, what's your phone number? 801 598
3199.
3199. And
Text it.
Yeah.
yeah, she'll put it in the chat. And I'm gonna let Tanner talk now and I'm gonna shut up.
Right here, right in front of the camera, right there. Okay, okay, cool. Awesome. I'm excited to be here. So I'm Tanner with Elevate. I actually am the new rep up here in Salt Lake, so I'm super excited to be up here. I was in Utah County before, so my wife and I live in Spanish Fork. We actually just bought a house about 6 months ago, so we're loving life. I've been married for a year, so I'm a professional now, right, guys? Like that's what they tell you you're supposed to be, but I'm definitely not. So a little bit about Elevate. We've been in Utah for 11 years. We actually have over 1,000 Google reviews now on Google, which is awesome. And we average 4.5 stars. So great for any company, but especially a home warranty company. You guys know we get a lot of claims. So that actually leads me to my first question. I actually brought Chick-fil-A, so there's a whole ton. And if anybody on Zoom wants to pop by the office, there's like food for 40 people. So hopefully somebody will swing by the office and you guys can share it with somebody else. So that leads me to my first question, and this is for a giveaway for this realtor hat. Everybody has free marketing, right? Like you can just wear it around town. So my question is, home warranty companies get a lot of claims in general, but what percent of those claims do you think are denied nationwide? So the nationwide average of denied claims, some are approved and fixed, some are denied. What percent of those claims do you think are denied? Shout it out. 50, what'd you say? 40? 60? 85? 20? Okay, you guys are gonna have to guess. I'm gonna give you guys a guess. So you're 20, you're closest. So you're gonna say 20. Okay, what are you gonna guess?
Oh, I know, guys.
Yeah,
17.
17. Okay. It's actually 13% nationwide. So hopefully that surprises you, a pleasant surprise, right? Because you as agents probably get the calls like, hey, my home warranty company's not covering this. You don't necessarily hear all the successes. So at Elevate, we've actually brought it from 13% down to 4%. And there's two reasons why we're able to cover more than anybody else. So does anybody know what a per item limit is for home warranties? Yeah, what do you think? What is it?
Well, I don't know the actual number, but I know every company has their.
Per item limit. Depends on the item, yeah. So actually, I always use this example because I think it's the best example. AC, for example. So there's a company here in Utah that has a limit on their AC unit of $1,000. So what that means, your client's AC breaks down and the home warranty company goes to pay that. They're going to pay up to $1,000 and then your client's out of pocket the rest of the money. Does anybody know how expensive it is to replace an AC unit? A lot more than $1,000. So it's like right around the range of like $4,000 to $6,000. So at Elevate, our top plan is actually $5,000. And our middle plan is $3,000, which is still higher than any local company in the state. So that's huge because it means when your client has an issue, we're going to cover way more for them and they have less out of pockets, which saves your clients a ton of money. So, and then number two, has anybody used the Domino's Pizza app before? I always use this example. So Domino's Pizza app, when you order your pizza, it shows it's like in the oven and then it has a little icon like from the car across the screen and then it shows it's at your house. So we actually at Elevate have some new technology that we've included into our plans where when your client has an issue, they actually can get on the online or on our app, or if they call into our office, they select 3 preferred time slots. The contractor's automatically notified, and then they select one of those. They show up, and they can get an automatic approval while they're there on site. So it just takes less time to fix items. So it makes it way easier, and your clients don't have to sit around waiting for a part to show up. They can just get it repaired while they're there. So the last thing that I'm going to share is we have something called inspection protection. So has anybody seen on an inspection before this unit is past its useful life? Like we recommend a contractor look at it. So that happens a ton. Most home warranty companies here in the state will look at that and say that's pre-existing. Like it was broken, it's old, we're not going to cover it. At Elevate, we actually will honor from the time it was inspected. If the inspector missed something or if they said it's working, we don't care about the age of the unit. We'll honor the home warranty from the time it was inspected until they close and even past that. So it's super nice. Because let's say they get the inspection and then 2 weeks later, even before they close, something breaks, we'll still cover that as a home warranty company. So pretty huge. We want to make sure your clients are taken care of and they don't have any surprises when they get into their house, especially like a $4,000 or $5,000 fix of their AC unit. So
protecting something like that or covering something like that before it closes, you have like a seller's coverage?
yeah, we have a free seller's coverage. And even if you get a buyer's coverage, this is the example I like to use. I actually had one of these yesterday. There was no seller's coverage on the property. The client got an inspection and then a day after they closed, something broke and then they called us. Our first question is, do you have an inspection report? We don't require it, but it helps out a ton. So we looked at the inspection report, the contractor said it was working, so we honor that and they got it fixed, even though it was like the day of move-in or a day after. So we also do offer free seller's coverage, so I 100% recommend that for you guys to use, because it definitely protects you during the listing period. So, okay, any questions? Any other questions?
What's your service fee?
So $75 or $70 if you do it online. And then we have 3 plans, $450, $600, and $750. There's people that are raising their prices like $700 right now. And our 600 plan competes with theirs and blows them out of the water. So I have brochures over there and I can hand them to you. And you guys can take a look.
So you allow if you have more money and save closing costs, can you bank money into your home market?
Yeah, so we actually, there's 2 things you can do with that, or 3 things, I guess. You can use that for prepaid service call fees. We can hold, I've seen up to like $2,000-$3,000 without any questions. Sometimes the lender will like look at it a little bit weird if it's more than that, but we've done it up to $2,000 or $3,000 with no questions. And if there's more, just let me know. I can see if we can get an exception. Yeah, so we allow it. You can use that for free prepaid service call fees. You can also use it for on-demand maintenance services. We're the only ones in the state that have maintenance services. So you can use it for like carpet cleaning or window washing. You can even negotiate that as an agent and say, hey, we're going to negotiate for some extra money, and then we're going to use that for house cleaning for 6 months. So all those on-demand services are in our plans as well.
Just purchase multiple years.
They can purchase multiple years. And then this is the last thing I'll share as well. If they have extra cash, we actually, after the first year of coverage, we can sometimes even cash them out that money. So pretty cool. Even if they don't use that money for prepaid service call fees or for our on-demand services, we can still cash them out that money. So pretty cool. Yeah.
What about rekey?
Rekey, we have that same thing. Yeah, you can do rekeys on all of our plans. Yeah, and even if you want, I have some free service call fee cards that are getting printed right now, and I can get you a bunch of them if you want to use them. So yeah. Okay. Sold. Boom. Okay, and then what I will say 2 last things. I'm gonna hand out some cards over here just as you're grabbing your food and stuff. It has my contact on there. Just save it in your phone. And then reach out to me with any questions. That's the benefit of knowing a home warranty rep, is if your clients have issues, just give me a call and I can fix it. So that's awesome. And then follow me on social media, Tanner Home Warranty. So I post on there.
Awesome. Actually, the last thing he said is the most important. The rep is more important than the home.
It is. It seriously is. Like I'll always pick up my phone. So even numbers that I don't recognize, I always answer my phone. So give me a call and
Welcome to Salt Lake County.
thank you.
Okay, thanks, Tanner. Appreciate it.